All right, you've been watching a CBS News special report. Again, to recap, the Supreme Court ruling just moments ago on the issue of birthright citizenship. Well, not exactly. So let's bring back CBS News contributor Rebecca Roiphe to talk about exactly what this means. So, Rebecca, we sort of teased it in the way that the press has been talking about it. And I think if you're a layperson, if you're watching this at home and you hear that the Supreme Court issued a ruling on birthright citizenship, you're going to go, wait a tick. I wonder what that means for people who are naturalized Americans, or perhaps the people who are the child of immigrants, as I am. But what does this injunction really uphold?
So what the Supreme Court said is not that birthright citizenship is constitutional. That was not the holding today. Very clearly, they did not address that substantive question. Instead, what they did do was hold that when one federal district court hears a case challenging the executive order, it cannot issue an injunction, something that stops the executive order from going into effect across the nation. It just doesn't have the power to do that. So that the executive order now cannot be enforced in those states that have where there are challenges pending, but it could at least theoretically be enforced in other states that have not considered this question. And so what really was decided was something about the power of federal district courts inside states to make decisions that affect the entire nation. And the Supreme Court said the judiciary just does not have that power. It hasn't been given that power by Congress, so it just can't do that.
And so is there, and Jan Crawford, who we're going to get on in just a moment, was talking about her feeling that that you're not going to see much movement in the way of people, for example, getting deported. But could that happen? And I want to make sure that I understand Jan's argument correctly, but her sense seems to be, as somebody who's not a lawyer, which is that there's going to be filings immediately in the wake of this decision from the Supreme Court. And we're not going to see a lot of movement for the things that perhaps people might be worried about versus the perhaps the celebration that may be coming out of the White House.
Well, I think she's probably right that, you're not going to see the, massive deportation of people who have birthright citizenship. But, I think this is an administration that has very much tried to do this, which is work around the law, like rather than respect the law, work around the law and get through the law and do things, that it might, that it might know it will ultimately be blocked, but do it, because there's some kind of impact that it might have. And maybe the impact is only kind of a scare tactic, but that in and of itself is significant. What this decision really did was give power to the executive. It made it so that the executive has more power than it did before. And, I think that has been traditionally something, not about the Trump administration, but conservative legal actors have been very interested in increasing the power of the executive. And that's what happened today. And so I think it remains to be seen, how much they will really be able to exploit that power at this point. But it's a power that they now have going forward. And I think, that it will affect administrations, again, not necessarily just this one, not necessarily just Republican ones, but, multiple administrations, because it just hands more power to the executive relative to the courts.
All right, so Jan Crawford is actually joining us now to talk more about this. So Rebecca, just stand by while we bring in Jan into the discussion. Our CBS News chief legal correspondent, Jan Crawford, who's joining me now. So Jan, explain it to me like somebody who took poli-sci because he couldn't get into law school. What does this ruling really mean? And I'm talking about me.
First of all, Vlad, I do not believe that you couldn't. That just shows your good judgment that you didn't go to law school. I do not believe that you could not get in. No, I think what this means, and I'm sorry, I didn't hear some of the conversation you had earlier, but this is really putting the brakes on one federal judge being able to kind of stymie policy from the executive branch across the country indefinitely. I mean, Justice Kagan in 2022 made that exact point, that it can't be right that one federal judge can just come in and block policy, which is what happened, say, in the Biden administration when conservative judges in Texas, where Republicans were filing lawsuits, entered nationwide injunctions, interfering and blocking some of his efforts on immigration, his efforts to forgive student loan, debt relief programs, COVID vaccines. So he was targeted with a number of nationwide injunctions himself, and in fact urged the Supreme Court during his presidency to please rein these things in. It's become increasingly, I completely agree, you see presidents asserting more power because why? There's a dysfunctional Congress. And so, when you have vacuums with immigration or other issues that presidents believe need to be addressed and Congress isn't doing anything, we've seen increasingly a use of executive orders. Now, Trump is, of course, taken that to the next extreme, which is why he's facing 40 or 50 or more of these nationwide injunctions. But what this means is the court is saying this is not how the system works. There is a way to get broad injunctions that will essentially cover the country, but you got to go about doing it the right way. And it can't just be a system where every case is, potentially suitable for a nationwide injunction.
So, Jan, what does that then mean while they go back and do it the right way? While the Supreme Court has issued this ruling, if you are now a judge in Texas, or if you are in Texas, and let's say you are one of these individuals who is potentially affected by this ruling, could that mean that tomorrow you could be deported while they try to figure out how to work this way through the system?
No, it doesn't. And obviously, the court is narrowing this injunction. It's still going to remain in place for the 22 states, the multiple organizations with thousands of members, the individual plaintiffs. That injunction will still be in place. You can't do anything against them. But moreover, there's a 30-day pause in this executive order. So there's nothing that would happen in the next 30 days. The Solicitor General made that very clear in the court. The justices were asking, basically, Vlad, your point, like practically what's going to happen. So in that period where nothing's going to happen, this is all on pause, the people will file lawsuits now seeking class action certification. So the justices at argument, and that was one of their big concerns, was, agreeing that courts could move quickly to basically block this, indefinitely, but just doing it the right way, doing it the right process. And obviously the court today was in multiple opinions by the majority, concurrences as well, suggested that this this is a case where it may have very little practical impact in the birthright citizenship case. I expect we will never see that executive order implemented.
So let's bring in Rebecca, Jan, to this discussion, and both of you can sort of weigh in on this. I'm curious now, as we put up on the screen there the makeup of how the court ruled. So what were the liberal justices, Rebecca, arguing? How did they interpret this?
Yeah, so I think what we saw from Justice Sonia Sotomayor and from Justice Jackson was a kind of preview of the ultimate question. So again, to be very clear, the court did not decide about the constitutionality of birthright citizenship, but in the dissents, what you saw was an argument that, okay, yes, there is a proper process, but there are certain cases where it would be appropriate for a single court to issue a nationwide injunction. And the liberal justices were arguing this is just such a case because it's so obviously unconstitutional, because it's so, clearly not considering the constitution or the legality of the executive order. This is where we should allow a court to come in. Now, of course, this is the dissent, so that's not the opinion of the court. But I think that what you see from these liberal justices was a sense not that, we should just willy-nilly allow any district court to issue a nationwide injunction in any case, but that there should be certain cases where it would be appropriate because of the clear disregard that the administration had for the law and the obviousness, how clearly unconstitutional the substance is. So then if you listen to her, she was reading it from the bench, or you read her dissent, you can see some of the arguments that will ultimately be raised, which when, as Jan said, the case reaches the substantive part of the case reaches the court in the appropriate manner.
And Jan, before we move on to some of the other decisions we're waiting for, your take on how the liberal justices saw this.
Oh, I think Rebecca nailed it. I mean, she's exactly right. And that's exactly what Justice Kagan said at the argument. You know, as I said, she's been very skeptical of these things and said that back in 2022 that courts needed to get a grip on them. But she said there could be an important case where you know, they were merited. And obviously the liberal justices believe this was exactly the case, that they should have done it. This was, you know, if you want to scale back nationwide injunctions, do it in another case. So, yeah, that is exactly right. And I think that Justice Barrett writing this decision is really interesting. Obviously, she's come under a lot of criticism from some conservatives who are frustrated with some of her rulings that have gone against Trump. She's a very careful justice, and she is not a justice, which is what frustrates some conservatives, who's going to swing for the fences. She's going to decide the case right in front of her in a generally conservative way. And based on my skim of this opinion, this is a very careful opinion by Justice Barrett that suggests that, setting aside what the liberals have said and the concern they have, that there are ways for courts to act quickly in cases like this.
Shades of Justice Sandra Day O'Connor, who perhaps came into the Supreme Court also with some conservative bona fides, but oftentimes, not a lot, but occasionally
I think that's wishful thinking by liberals. Yeah, no, she's conservative. I don't see her being one of those conservatives who, but we'll see, Vlad. That's the thing about the court. You know, they'll surprise you in 5 or 10 years.
That's right. That's right. So let's talk about some of the other decisions that we're waiting, because to remind our viewers, this is actually the last day of the term, Jan.
Well, I'm frantically pressing the refresh button, you know, because I've got it on the Supreme Court website, which is where the opinions just pop up when they're being released. We should be getting another one any second. There's 5 left to go in this term. Today's the last day of the Supreme Court's term. There are several that are highly significant cases, including one from Maryland that essentially involves a lawsuit by parents of elementary school children. They say that their deeply held religious beliefs mean they should be able to opt their children out of story time when it involves some of the books that the school board had selected that really kind of embrace gender identity and other LGBTQ issues. That is a big religion case that we should be getting any minute. That's one. But then we have a voting rights case from Louisiana that could be significant on when states can consider race when they're drawing up legislative districts. That's a big case that has practical implications, too, for Democrats and whether or not they're going to pick up additional seats with, you know, Congress so narrowly divided. And then we have a case from Texas about online pornography and whether or not states can impose age restrictions and verification to kind of keep it away out of the eyes of kids. The porn industry is arguing that that violates the First Amendment right of adults, and so the court has to decide if states can ask for that kind of age verification for online porn websites in the interest of protecting children. Pretty much as you have to show, obviously, I mean, this came up at argument. It seemed like Justice was saying it's like common sense. You know, you have to show ID to get into a strip club, to buy a Playboy, to go in the back room of like the adult video section. So why couldn't states require some kind of age verification to get that same kind of material online? I expect Texas will probably win this case, but we'll see. In a matter of the next hour, we'll know, Vlad.
Yeah, and it's so interesting, Jan and Rebecca, that we obviously had the special report around this case regarding birthright citizenship obliquely, but these other 3 cases that you mentioned, Jan, seem to be more consequential to me, at least in the immediate next couple of days, in our immediate futures as Americans. And I name-checked Sandra Day O'Connor. You know, I'll never forget, the very first time that I became aware of how Supreme Court justices could be sort of pithy but also funny at the same time, Potter Stewart saying he doesn't know he knows what pornography is when he sees it. I'm paraphrasing it, but that became the term, right? Like, I know it when I see it.
You know it when you see it. Yeah,
you know it when you see it. Yeah. All right, Jan, Rebecca, stand by while you refresh that Supreme Court website. While we await that, let's go. Are we going to Natalie or to Scott, guys? All right, we're going to go first to Scott McFarland on this, and then later on to Natalie Brand, who's tracking all of this from the White House. But Scott, let's go to you. You have been standing by. You've been tracking all of this as well.
Yeah, Vlad, first of all, let me just set the scene at the Supreme Court. A pretty muted group here today. This doesn't bear any resemblance to what we saw here last summer when the Supreme Court made that landmark ruling on presidential immunity. But the timing of this ruling is not inconsequential at all. It's the end of the term, but it's also right in the middle of this multifaceted battle the administration is having with the court system. Some of it's legal, some of it's political. The legal cases are frequent and growing across the country. You know, the administration has sued to overturn court orders or just challenge the judges themselves. In a case that was filed this week, Vlad, the administration, through the Department of Justice, sued every sitting federal judge in Maryland over an argument over how the court system in Maryland is processing some immigration cases. They're also accused by critics of defying court orders, including that court order to famously turn around that deportation plane that was headed to El Salvador on March 15th, and not promptly returning Kilmar Abrego Garcia, the man mistakenly deported from Maryland to El Salvador in March. So you have those legal battles, but at the same time, Vlad, there is a political muscle the administration is flexing as it criticizes the courts and overreaches by the courts. One of the top advisors at the White House posted judicial coup on social media when he disagreed with one of the recent court rulings. You can just see here the administration is having quite a time in its first 5 months battling the federal court system.
Yeah, for sure. Scott, we're going to keep you there in front of the Supreme Court because we're still awaiting those 3 or 4 other decisions. But while you stand by, I want to go to Natalie Brand, who's at the White House for us. And Natalie, you've heard the way that Jan Crawford broke down this decision, and you've heard Rebecca Royfe's explanation of the decision when it comes to birthright citizenship. But now you've got the White House and the politics that politicians inject into these court cases. And so the question becomes, you probably don't have reaction just yet from the White House, but how has the president of the United States and the administration been talking about this case leading up to this decision?
Yeah, and Vlad, it is surprising we don't have reaction quite yet. We've been monitoring all of the social media accounts. It's possible that the White House is waiting for the president himself to weigh in on social media, which sometimes happens when you're dealing with big developments or decisions like this. But, you know, this is a victory for executive power and the president's ability to enact policy without a single lower court judge having the ability to block it with a nationwide injunction. And we know that this is something that presidents of both parties have struggled with over past years. Jan alluded to that as well, because we've seen, you know, conservative states or liberal states take action with some of these policies and be able to really set the tone for the whole country. Now, critics warned that with this ruling, you could see a patchwork of different decisions across the country. Something else you've been talking about with Jan and the other legal analysts is this didn't touch the issue of birthright citizenship, which was this executive order that the president signed, right on day one to try to shape his immigration agenda. So we're really waiting to see what happens with next steps here in light of this new major ruling. What actions does the administration try to take on that front, and overall in trying to enact other policies given this major decision by the Supreme Court to really partially block a lower court's ability to stop a policy outright. The argument that we heard during oral arguments was, and in past years, was maybe this should be, the domain of federal appeals panels or the Supreme Court itself. One note, too, in the dissent, Justice Sonia Sotomayor writes that no right is safe in this new legal regime the court creates. Vlad.
Interesting. Natalie, so you're going to stand by for reaction from the White House. And if you do get reaction and you're still standing in front of that camera, you can do the Gayle King wave, which is the wave to the control room that you've got some news to report, and we'll come straight to you. Natalie Brand for us at the White House. Let's go to CBS News legal contributor Jessica Levinson, who's also standing by to talk more about this. So I want to dig a little deeper, Jessica, into the dissent. And you just sort of heard what Natalie said there in quoting from Justice Sotomayor's dissent. I'm just curious if what you're seeing in just that sentence that she quoted to me, which is that certain justices of the Supreme Court recognizing that we live in a very politically charged time that is perhaps different than times previous, and that calls for a more, I don't want to use the word thoughtful, but a different approach to how these justices think about the letter of the law. Understanding, of course, that there are some of those justices who sit on the bench who are strict and, that when they look at the Constitution, they interpret it exactly the way it's written, and there are others who feel differently.
Vlad, I love this question because in my mind, and obviously it's a very lengthy dissent and I'm just trying to get into it, but this is a vintage Sonia Sotomayor dissent where she's saying, look at what is going to happen on the ground now. And I would say right off the bat, the conservative justices and others, I think, would say the practical impacts that she's concerned about may not happen. But I will say, as somebody who teaches her opinions, this is very much consistent with the way she writes, which is look at what will happen to individuals on the ground today. And she spends, as far as I can see, the beginning of her dissent really focused on this question of birthright citizenship. I'm sure you've talked to Jan and Rebecca about the fact that this case really wasn't about birthright citizenship at all. In fact, it was about the scope of relief that federal judges can provide when somebody walks into the courtroom and says, there's a problem with this executive order. And I don't think that there is a majority of the court not near it to say that this executive order about birthright citizenship would be constitutional. But you do see, I think, this fascinating divide where Justice Sotomayor is spending a lot of time talking about what happens to people who are pregnant right now. Will we have stateless children? And this is really what she has done in other areas. Think about affirmative action, think about abortion, think about immigration. And then we have different opinions looking at the implications of what would happen under the law if we give federal judges the power to do this. It's a very different reading of the consequences we're worried about. It's a very different reading, in some ways, I think, of the power of federal judges.
Jessica, let me ask you about some of these other cases that we're waiting for, including the one that has to do with children's books. And it's so interesting. And people can be mad at me, but 3 years ago, before I had a baby, I probably wouldn't have thought much about this. It wouldn't have affected my life much. But I am curious as to the merits of this case, how it started, and how you feel the justices might rule on this one.
So this is a case involving whether or not parents have, under the First Amendment, the Free Exercise Clause, a right to essentially have notice and opt out before their children are read certain books. In this case, about LGBTQ families, I believe, were the main books that we're talking about here. And Vlad, to your point, I heard Supreme Court justices saying the same thing, which is life experience matters. I heard Justice Amy Coney Barrett, who has a number of school-age children, saying something like, you know what, these are real important questions. And I think it matters. And this is true in another case, dealing with another case that, as far as I know, we're still waiting on, dealing with whether or not age restrictions in Texas in order to get onto websites that have adult content are permissible. But when it comes to this question that you asked me about, and it comes to the parents who are saying we need notice, we need an opt-out before our children are read certain educational materials, I think the court is going to rule with the parents. I think the court felt that there should be some sort of opt-out for them. And the question, of course, is how they craft that opinion so that it does not allow parents to say, we don't want our children to have basic education in U.S. history, in math, in science, but it does allow parents with genuinely held religious beliefs to say, we don't want our children to hear this type of educational material. That will be difficult for them to craft that opinion.
Yeah, I do think that's sort of interesting that you say that, Jen, because my first thought went to, okay, well then if the court then rules that parents can have the opportunity to opt out of that story time, for example, if it has material that they don't feel comfortable with for religious reasons, what's the line when you say, hey, let's talk about enslaved people in this country and what that meant and what that has meant for this country? What about Jim Crow? All the things that you're starting to sort of hear now that people kind of don't want to talk about, that they don't want to teach in schools. What would be that line for a parent to say, you know what, I don't want my kid to hear about what it was like to be enslaved in this country, because they're too young to understand that, and where the line would be drawn in that way?
Well, Vlad, I hate to give you this answer, but we're going to know in 7, 10, 17 minutes. I don't know, but we will see how, if I'm right in the prediction. And I don't know if Jan can still hear, but I think that we both listened to oral arguments and believed that the court was likely to side with the parents. It's important to know in this case, the school previously did have an opt-out provision for the parents. They took that away. And I think what the court was saying here is allow that opt-out. It's not too much of an administrative burden. To your point, though, I think this is going to be the hard part for the court, right? Saying that you have to allow parents this opt-out, but you can't allow parents to say, don't teach evolution.